Welcome to Guardians of Innovation, Patent and Trademark Law.
Hey there, and welcome back to Guardians of Innovation with Vincent LoTempio. Vincent is a registered patent attorney with over 25 years of experience helping inventors, entrepreneurs, and businesses protect and profit from their ideas. My name is Kevin Rosenquist, and today we're talking about why intellectual property matters so much to investors and how startups can build an IP portfolio that boosts credibility, attracts funding, and sets the stage for long-term success. Vincent, welcome back. It's good to see you.
Hey, Kevin, nice to see you again. I'm really looking forward to this episode.
Yeah, for sure. So why do investors care so much about intellectual property when they evaluate a startup?
Well, at the end of the day, it's all about competition. And what happens with intellectual property, it allows you to have a monopoly. The patent gives you a monopoly for 20 years on the product, a copyright 70 years plus the life of the person plus 70 years. And for a trademark, it's infinite, right? If you just pay your maintenance fee every 10 years, you can own that forever. So the whole idea is, and I always say, look, it's probably a good thing if somebody's copying you. It means you're making money because as soon as you start making money, everyone's going to try to copy you. And the only way to stop them from copying you is to have, a portfolio of portfolio of intellectual property.
And what does that portfolio actually include for a new company?
So, usually they have one product that they're starting with, and then they kind of build from there. And there's different ways to protect that product, through patent, trademark, and copyright. And yeah, I guess it could be simple as just the name. You have the George Foreman grill,
Hmm.
and nobody else can put the name George Foreman on it, versus you have the grill and nobody can make this grill the way you've made it, either by design, what it looks like, or by utility, how it works. If you can protect that, you can stop people from competing with you, then you can work on other ways to make money from it. IBM is the biggest, deepest portfolio of patents of anybody else in the world. Every year they're number one on the list of number of patents that they file. And they make a big percentage of their money n- from doing nothing but licensing that technology through those portfolio of patents.
Right, right. I had a George Foreman grill. It's an electric grill that was just tilted.
Yeah, and everything dripped off of it.
And
Yeah,
everything
we
dripped off.
everybody had one. I had one too.
Yeah, yeah, for
Yeah,
sure.
yeah.
How early should founders start thinking about IP, especially if they want to impress or court investors? And what's the very first step to get started?
Yeah, I mean, the first step is acknowledging and understanding what is patentable subject matter. And a lot of times, inventors or even engineers that would work on this look at it and say, "Oh, this is so easy. It's probably not patentable," when in fact it is. So the first step is to identify what is patentable subject matter and what do you have and what is protectable, whether it's trademark, copyright, or patent. So once you understand that, you make sure that you protect it through registering it, either through patent, trademark, or copyright. One of the things that we try to do when writing a patent is try to really dig deep and see what's out there against it and have a really solid search and have information presented to the patent office right off from the back. It's called an information disclosure statement, an IDS, where you want to give as much information as you can so that when somebody does go to invalidate your patent, we just talked with Wayne Fromm on the previous episode, and he says, the first thing they try to do is attack your patent. And if you have a strong patent, it's harder to attack it. So, if we hid something for them from the patent office and we got the patent, and then somebody else finds it and they attack our patent, we're still going to lose it. So we
Hmm.
want to make sure that we file it correctly, and that we have very strong intellectual property, and that's where a patent lawyer comes in. Now with AI, I get people calling me saying, I've created this patent application from AI and it looks great. And to the untrained eye, it looks great. And even to me, as a patent attorney, it's a good starting point, but there's so many flaws in it that have to be cleaned up, that that unless you're a registered patent attorney and you're able to and you experience all these things over the years of how things have been allowed and how things have been rejected, and certain formatting and certain things that you want to do, it's not as simple as just doing it yourself, and that's why it's important to hire a registered patent attorney with experience.
I can also see from an investor's point of view, it kind of adding legitimacy, like adding making it seem like, okay, these people are serious, they're doing the right thing, they're going through this business, they're doing this business in the right way. Does that do you feel like that part of it makes a big difference for investors as far as their interest or their trust?
Absolutely. I mean, you put people on notice. I'm sure you've bought products before with the little R on the name, and you say it's
Sure.
been a registered trademark. And you see, patent pending written on a product. You know that if I try to copy this, or there's a patent come out of the woodwork and torpedo me and stop me from doing it. So just those things give it a little bit more legitimacy, like you said. And if you've gone to the point where you've already established goodwill in the marketplace, and you've come up with a good product, you have a good name that's recognized, all those things have great value. I always say this, and I've been saying it since the beginning. If I were to offer you, Kevin, right now, all the brick and mortar, all the liquid assets and of Nike, or give you the right to use the word Nike or Nike swoosh, what would have more value? I would argue that the swoosh has more value, because you're not going to be able to sell all those sneakers if you don't put that Nike name on it and the Nike swoosh. So that intellectual property is extremely valuable.
Hmm. Yeah, no doubt. And so when it comes to investors, serious investors, what things do they check for on the IP side? Ownership, disclosures. What are they looking for that startup should be ready for?
Well, yeah, those are good things that they look for. But yeah, I mean, I work with big companies, and a lot of times they sell. Maybe their subsidiary, or sell them, they get sold, or they buy other companies, and I work on the IP side of it and try to vet where everything is, to like when I say where, what countries they've been filed in, what types of patents they have, what types of trademarks they have, are all the maintenance fees paid up, are they still live, are they dead, do they need to be revived, is it possible to even revive them? So I think the biggest part for startups is to record everything, and keep like an inventor's notebook, or keep a file on the hard drive, in the office someplace, with a document, like a disclosure document, that says, new inventions, and I've created these disclosure documents for companies. And so when employees are making these products, they describe it well enough that if they leave the company, somebody else can pick it up and run with it. And it's established that it was invented at the time they were employed, so the employer owns it. So some of that paperwork too is just contracts with the employee, saying, look, everything that you create while you're working for us, we own the intellectual property. And even if you leave the company in the future, you still have to cooperate with us and sign whatever documents are necessary to get this stuff to go through the patent office. So yeah, I think documentation of when and where and how it was invented, and in contracts with the employees, stating that this was created while I was working here, and then it's the ownership of the companies.
When it comes to trademark protection, how important is that for startups, and is that something that investors are going to prioritize as well?
Yeah, I mean, again, I go back to the Nike example. Imagine if they didn't protect the swoosh, or they didn't protect the name, and somebody was able to take it. In fact,
Hmm.
a woman who was in high school created the swoosh for them. They paid her $35 or something, and she bought her prom dress with it. You know, and imagine if she owned the Nike swoosh because they didn't have her sign off on it. So I think it's very important that you own it, and especially if it's something that you think that's going to grow and be part of the company. And sometimes names change, and slogans, or even the you know avatar of the company changes over time, but the name usually is solid and it stays there, you know. And so, yeah, I think it's important right off the bat to make sure you have a solid name that nobody else is using and that nobody else can use. And I've seen situations where they've come to me afterwards and didn't file it, didn't do a search to see if it was available, and they're about to put 75,000 cases of apple cider into all the stores on the East Coast from Boston to New York City and Connecticut. And they basically mortgaged their house to do that. And then some company out of Seattle sends them a letter saying, take all those labels off 75,000 bottles. I mean, that's nightmare, right? I mean, and that's a true story, and so
Wow.
yeah, protecting it and being sure that you're the owner of it and that nobody else can use it is vital to your company, and that could be the difference of making it or breaking it. And talk about, what do they call it, penny wise and pound foolish. For a couple $100 to do a search on a trademark to see if it's available and to protect it, versus the money that it's going to cost you to relabel 75,000 cases, and all the goodwill that you've obtained by selling whatever you sold up to that point and having to change the name. It would just be a nightmare, right? I mean, it just doesn't make any sense not to protect it.
Absolutely. Yeah, absolutely. Also, I feel like, a lot of times it's, startups have limited funds. They're stretched pretty thin a lot of times. So I wonder if that's part of the reason that sometimes that they let some of this stuff fall by the wayside. But for any startup out there that knows they need to get in on this stuff and doesn't have a lot of money, where should they start? What should they prioritize?
Yeah, that's always an issue. And today I was on the phone. I basically charged $1,200 for a trademark application, and that includes the $350 fee. And I got a phone call today, and the first thing they asked me, "What does it cost?" And they just hung up on me when I told them the cost. But I always say, look, I don't bill by the hour. I do a flat fee, so you can pick up the phone and talk to me as much as you want. And I don't just file it in a way that you're just paying me to file it. It's all the legal advice that goes along with it. I'm going to make sure that the way you put your labels on your product, the way you put it on the website, the how you use the trademark, and all the other parts of that application are done just right prior to filing it. And I say, call me on my cell phone, call me directly. You don't call my answering service or my secretary, and I'll walk through you. And I'm not going to nickel and dime you to death with an hourly rate, where a lot of the big firms, they might quote you $1,000 and you end up spending six, because every time you pick up the phone, it's a $95 phone call for 2 minutes.
Hmm.
But yeah, I mean, you got to figure out how and where to place your funds. And like you said, what's the most important thing to do for patent law? You can file what's called a provisional patent application. It's a lot less expensive to file because it doesn't have all the formalities of a non-provisional, full-blown application. It's a big price variance. But the thing with the provisional application is, it it never becomes a patent. It just holds the filing date for a year and gives you a year to file it. So you can go out there for a year and see if it's going anywhere and decide whether to file it or not. I filed a patent with a guy that had an idea for the maple syrup um, um, industry. And he had me do a provisional. And then 2 weeks later, he called me and said, "Oh, I just signed this huge deal with a big maple syrup company out of Canada. We need to file the non-provisional right away." And so he didn't take a year. He just filed it right away, 'cause something happens. But yeah, I mean, when you're first starting out, you have to pick and choose. If you look back in history, one of the biggest companies in the world, Apple, was started by Steve Jobs and Steve Wozniak, and um, one of the things they did to protect their software, because they couldn't afford patents when they first started, was protecting it with copyright. So copyright protects like a work of art, and like a book would be considered, in the arts, right? And the language in your computer, the source code is like writing a book in a new language. So basically, although it doesn't protect what that software did, it protects them from just taking your source code and just copying it. So they basically protected it using copyrights. And of course, I imagine now, they're one of the richest companies in the world. They protect all their intellectual property through patents. So the reason why you can do patents and copyright for software is because how I just explained the software component of it, the utility of it and how it works. That's what protects the patent. So if you protected it with a utility patent, it wouldn't matter what the software was. I mean, it wouldn't matter what the source code was. You could use any source code to create this software to do what it's doing, and you'd still be protected. So the patent is much more robust protection than the copyright, but there's different ways to finagle it to protect it. And then there's non-disclosure agreements and licensing agreements where you could, before it goes public, have a written deal with somebody that, look, this is how it's going to work, whether we get the patent or not. And, this is how I'm going to get paid and what our milestones are in this contract. And so there's a lot of different ways to finagle it. And I always say for entrepreneurs to pick the low hanging fruit. And the low hanging fruit is whatever you can get for free. And one of the things that they have throughout the country is the Small Business Development Center and the SBA, which are federal programs that allow you to get a counselor and put together a business plan. And they don't charge you anything.
Yeah.
So, maybe it'll help you. Maybe you only learn one thing. They didn't teach you anything except for one thing, but it's, as my wife says, low hanging fruit, and you got to pick the low hanging fruit.
Absolutely. What would you say when it comes to attracting investors with an IP portfolio? What would you say the biggest mistake startup founders make when they're creating it?
Well, I think the biggest mistake is just thinking that I can just make this presentation on a napkin and they're going to love the idea and they're going to run and do everything. So I
Hmm.
think what you have to do is be at the point where when you're in front of that investor or you're in front of that venture capitalist, you have a great presentation all set and you have a lot of these answers already figured out. It's not like, oh, this is the idea, you got to figure everything out. Because venture capitalists, they're cherry pickers. They want an easy way to invest their money and make money, and they want to see a clear path to it. They don't want to have to figure out all the stuff that Wayne Fromm had to figure out on his own. They want you to have that all lined up, and all they're going to do is infuse money into it, and it's going to go. So you really need to have that business plan. You really need to have that presentation. And it can't be just a simple email to somebody in the company by random. It has to be meet them face to face, look them in the eye, have a presentation ready, and be able to answer any of those questions. It's kind of like being on Shark Tank. Listen to the questions that they get. Have you filed for a patent? Have you done a patent search? Are you sure you can get the patent? Did you already get the patent? Have you had a beta test? How much does it cost to manufacture it? Where are you going to store it? How are you going to deliver it? How are you going to market it? Who's going to like it? I mean, those are the type of things that they're going to want to ask. And those are just one, just a few of many things. Is it made out of lead? It's going to cost us so much money to deliver it by mail, or is it made out of light paper and it's going to be easy to ship and easy to move? Those are all, there's just a huge checklist of things you need to do, but you need to be able to answer all these questions and tell them exactly what you need them to do and why it's going to be a success. But ideas don't sell themselves.
Right. Right. I think that's great advice. All right. Well, thanks for listening to Guardians of Innovation with Vincent LoTempio. If you're a startup founder or entrepreneur looking to build investor confidence with a strong IP strategy, Vincent and his team can help you protect your ideas and position your business for growth. Visit lotempiolaw.com to connect. And if you found today's episode helpful, don't forget to leave a review, subscribe so you never miss an episode. We love having you be part of our community. Thanks, Vincent. Always great chatting with you.
Thank you. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.